we are going to be speaking on intellectual property and how we can protect your company's assets. So before we begin, I would like to give each of you a moment to acknowledge and respect the lands you are situated on. So for myself and Tony, we are here in Vancouver. So we would like to thank the Squamish, the Tsleil-Waututh, and the Musqueam people for allowing us to live and work on their unceded territory. So Tony, if you didn't catch on our slides, he is a senior manager here at Crowe in our scientific research and experimental development consulting practice, otherwise known as SHRED, and he is our in-house IP consultant. He brings over 25 years of experience in both IP and product development, as well as in SHRED. And before joining Crowe, he held a managerial position at one of Canada's largest companies, recognized on the 2020 Forbes Global 2000 list. So thank you, Tony, so much for joining us. I will talk a little bit about who we are as a firm. We are a team of 400. We're situated in 8 offices across Western and Northern Canada. That includes Alberta, BC, the Northwest Territories, and the Yukon. And we are a member of Crowe Global. This is one of the top 10 accounting networks in the world. And we get to work with them. It allows us to collaborate and really bring global expertise to our client work. Outside of our traditional services that we do, our taxes and the audit work, we also have a suite of advisory specialist services. And that includes a lot of succession planning, financial planning, looking at your business as a whole and business consulting, digital transformation of your business's operations, as well as implementation and enhancement of your cybersecurity operations. So I encourage you to contact your local Crowe Mackay advisor, whoever it is that you work with, or if you are maybe looking to explore any of these options, you can contact your local Crowe office and we can help you with those. So before I turn it over to Tony, I do want to go over some of the housekeeping, really just how you can engage with us. So if you look at the bottom of your screen, there is an option there that says Q&A. That's how you can ask questions to Tony throughout the presentation. We're going to be stopping 3 times. The presentation is broken up into 3 chunks. We'll be looking at trademark, patents, and copyright. So if you have questions at all, just throw them in there and we'll address those at those times and keep it as relevant and timely as your questions come in. So other than that, Tony, I'm going to throw it on over to you and let you kick off the presentation.
All right. Thank you very much. Let's see. Trying to share. Okay, there we go. Can everybody see that?
You are good.
All right, excellent. All right, thank you for attending. I appreciate it. Just wanted to give a quick little primer or introduction to intellectual property. It's a pretty in-depth topic, so I would consider this more of an introduction than a comprehensive discussion, but I'll give you the core information that you need. And I'm trying to scroll and it's not working. Okay, there we go. All right. So we'll start with who Brittany's already introduced, Crowe Mackay. Myself, I'm an engineer by training, so this will be more of a practical kind of discussion of IP. As you can see, I have a lot of experience in product development and intellectual property at several different firms, including Magna International. So basically, you know, we want to talk about, you know, this concept of intellectual property. I think there's a lot of misconceptions about it and a lot of misunderstandings about it. And I just want to emphasize in this discussion about how it's really an important tool for you. And it's a tool that you can use proactively, or it's a tool that you can use defensively to protect yourself against infringement action. So it's a positive and negative, or yin and yang kind of thing. So in terms of intellectual property, you know, the legal definition, I guess, is, you know, it's a product of the brain that can be owned. I'm not too happy with that definition, being a practical person. So, you know, I ask myself, well, what does that really mean? And when I think of things as an engineer, I think, you know, what makes a product successful? And I think about, well, you know, the product probably has some kind of functional improvement over existing products. You know, like, for instance, when Apple came out with their phone, the iPhone, it was so much, you know, better than using a BlackBerry, which I used to have a long time ago. that sort of thing. So, people can see the functional improvement and they get, more interested in that product. There's something about the attractive design, which again, the iPhone is a good example of that. It was, a lot nicer looking phone, much brighter display, etc., than the BlackBerry of that era. You think about the brand name of the product, Apple has a pretty high brand equity, and many other companies as well. And then you think about promotion and advertising, you see the television commercials or YouTube or etc. So to me, those are sort of the four main factors that I think of about what makes a product successful. And when you take those four factors and you think about IP behind that, you basically cover most of the important issues that we're going to talk about. So for functional improvement, you would use patents or trade secrets to protect that. We're not going to really talk about trade secrets, but that's obviously something that you keep a secret, proprietary, and don't reveal to anybody. Patents have a life of 20 years. We'll get into the details of all of these types of IP. The design of something, the product appearance, is usually protected by something called an industrial design. That's the term in Canada uses, and it's a 10-year life. And in the United States, they just call it a design patent. And in the United States, it lasts for 14 years instead of 20. And so branding is usually protected by trademarks. And trademarks can potentially last forever, but they do need to be renewed every 10 or 15 years, depending on the country. And they arise from commercial use. And then finally, with the promotion and advertising thing, that's protected by copyright. And copyright usually lasts for the life of the author and plus 50 or 70 years. So an example I like to use is the Dyson. James Dyson invented the Dyson vacuum quite a long time ago. And it took him quite a few years to refine that product. Over 15 years and over 5,000 prototypes. And so here's an example of that table that I showed earlier. For the Dyson vacuum, if you look it up, his first patent was in the United States. The numbers listed there, and he's got more than 50 other patents that he kept filing for improvements to his design. He's protected it with at least 90 design patents. One example is shown there. He has quite a few trademarks in both the logo and the word itself, Dyson. And in terms of the copyright, he has quite a few different websites, sales brochures, manuals, etc., etc. So we're going to focus our talk today on just the three main types or most common types of intellectual property, which would be the copyright, the trademark, and the patent. So they are all treated very differently under the law, so it's important to sort of get a handle on what it is and what it isn't, and I'll be providing some summary tables on that. And some rights are positive and some rights are negative. And positive and negative means you can either proactively do something or you can exclude others from doing something. That's what I mean by negative and positive. And in some cases, your IP rights are lost if you don't enforce it. And in other cases, that's not the case. You don't have to enforce it. So with copyrights, copyright essentially means legally the right to copy. So it protects original expressions of ideas, and then things like, sound recording, books, movies, etc. And it must be in tangible form. So in the modern era of internet and things where you don't normally have things like books and DVDs, most of it is online. It can still be considered tangible if it exists somewhere on the cloud or can be reproduced at will. So it doesn't have to be a physical product like a DVD or a book. It's still considered tangible. And so copyrights have both positive and negative rights. So for positive rights on a copyright, you have the right to make copies, make changes to the copies, etc. Perform, display the work, make adaptations, etc. And it has the negative rights to prevent others from making copies, changes, distributing, or publishing the work. So the key, I think, with with the negative rights is you do have to be careful with you know, how, the degree of copying. So you don't have to, so what I'm trying to say there is, for infringement issues, if you photocopy part of a book, you're still, you know, violating the copyright of that book or a movie or that sort of thing. So it doesn't have to be the entire work that you're copying if you're going to get offside with infringement. So you do have to be careful. If it's a substantial copying of a work of somebody else's, then you would be liable for infringement. So in terms of the owner, usually the creator owns an automatic copyright, even if he hasn't registered it with the government. And in terms of a business setting, usually it's the employer that will own it. But when you're dealing with independent contractors, they will naturally own the copyright unless there's an employment clause that says that the employer that's paying for the work from the contractor will get the rights to copyright. So that is an issue that has to be addressed sometimes. So a practical example here is you see at the bottom left of the slides, it says copyright 2022 Crowe Mackay. This is really an official legal notice that you cannot use these slides in a presentation. It doesn't prevent you from doing a similar presentation covering the same topics but with different examples. It just, you know, protects the exact expression of the ideas. So in other words, nobody can copyright an idea. They can just copyright the exact expressions of this idea. So in other words, the way I'm explaining it today, you couldn't just take my slides and use them for your own purpose, but you could certainly discuss the three topics of, you know, copyright, trademark, etc., in your own way. So copyrights usually last for the life of the author, the remainder of the calendar year when the author dies, so December 31st, plus either 50 or 70 years in most countries. Some countries like Mexico are 100, but usually it's 50 or 70, so it does depend on the country. And copyrights are interesting in that they don't need to be enforced, unlike trademarks and patents. So that is an important issue to keep in mind, that even if you don't enforce your rights, if you become aware of somebody infringing your copyright and you choose not to do anything about it, you don't lose your rights to stop others from copying it at a later time, but that is the case with trademarks and patents. So before we get to trademarks, I just wanted to see if there's any questions on that.
Yeah, I have one here that's come in, Tony, talking about fair use. So they're asking if they'd be sued if they used copyright material in a limited way, like a teaching environment or news reporting or research.
Yeah, that's a good question. So there is something called fair use doctrine. And what that means is if you're using the work, somebody else's copyrighted work, for a non-commercial use, and you're using it for teaching or research or anything like that, you have fair use. You can do that without being sued for copyright. But if you're trying to take somebody's copyright material and get a commercial gain out of it, you're going to be offside right away. And if you take somebody else's copyright material and you use it in even if you're not doing it for a commercial gain, but you're doing it in sort of a disparaging way or something, impairing the reputation of the copyright holder, you would also be offside in those cases. But if you're just using it for your, you know, non-commercial use, and you're not, you know, slamming the reputation of the owner, and you're just using it in a very limited way, you're fine.
Okay. How about purchasing copyright? Can you talk a little bit about that?
If it's a registered copyright, you can sell, like other forms of intellectual property, you can, it's an asset. So you can sell it, you can sell exclusive rights to it, and other people would then be able to, you know, make use, you know, exploit it the way you would own it as well.
Okay. So when you're purchasing copyright, is it then again for 50 years?
Yes, that's right.
Perfect.
50 or 70, yeah.
Depending on, yeah, where you are. Awesome.
Yeah.
Okay. Alrighty. Well, let's continue on. And if any others come in, we'll get them at the next question period.
All right, great. Okay, so for trademarks, the key point that you should keep in mind is it's always association. So when you see that little swoosh, I think everybody thinks of Nike. And that logo design was actually designed in 1971 by Carolyn Davidson for 35 whopping dollars. And it really means, it represents the wing in the famous statue of the Greek goddess of victory, Nike. According to legends, a Greek warrior would say, when we go to battle and win, we say it is Nike. So I had to look that one up, so that's why I'm reading. But that's an interesting origin of Nike, not to make people think about that. So it's really the important thing is, it's what consumers or customers would associate, a product or service with. So everybody is seeing, Coca-Cola, BMW, Yahoo, Google, etc. These are all protected trademarks, and the ones I'm showing there are the earliest examples of the registered trademarks. There's quite a few trademarks associated with Coca-Cola, BMW, Yahoo, etc. And in all three of these cases shown, these trademarks have evolved over time. They look different over the years. So when you change a logo, and you want to protect the new version of your logo, you're kind of obliged, if you want a registered trademark, to refile it. So these companies that are shown and others have quite a few trademarks associated with their product. So the R circle shows that it means that the owner is registered. So that means that they have the exclusive use to use that. So it's a positive and a negative right. So the question I have, and we'll get back to it, is, would I infringe if I started selling power tools in the United States under the name BMW? And the question there would be, like, BMW is usually associated with cars. If I use the same BMW name and I start selling power tools, would you be, infringing or not? So we'll get to that question in a few slides. So trademarks, like copyrights, don't have to be registered. You actually acquire use rights through commercial use. So just using the name, if you launch a website and you have, your trademarks, gee whiz, whatever, you can, go ahead and happily sell product as long as it's not infringing somebody else's similar trademark, and you have some rights. But if you register your trademark in the national offices of each country, you would automatically get national rights instead of just local rights where you're doing commerce, and you could prevent others from adopting the similar trademark. And it also makes licensing a lot easier. So there are some advantages of filing, and both copyrights and trademarks are pretty low cost ways of protecting your intellectual property. Patents are very, very expensive. Copyrights are usually a few $100s, and trademarks are always less than $1,000. I've never seen a trademark bill for more than $1,000. So trademarks are renewable for every 15 years in Canada or 10 years in the United States. And they do expire from lack of commercial use. So you will see instances where companies have used a name and the company has gone out of business or changed for focus and they don't use the name anymore. And you sometimes see other people pick up the same name and use it for another purpose. So you do have to continue to use it in a commercial setting to retain your rights to a trademark. And you also need to be enforcing your trademark. So if somebody is starting to use a similar sounding name than yours and you don't do anything about it, basically they can argue, and you were aware of it for quite a while and nothing happened, the infringing party could actually come back and say, well, you abandoned your rights. So I would argue that any company should be considering branding right from the beginning, because consumers or customers will always usually buy branded products, and they think about the reputation of the company as well. And so, to me, if you're not spending time thinking about branding of your product and service, or your company name even, that could be an issue. So the most successful businesses have made up words such as eBay or Amazon. And the issue with trademark registrations are you can't really file a trademark for a descriptive name. You can't say, you know, best pizza, and then, you know, I'm going to get a trademark on that, and nobody else can use the term best pizza, because that would be, you know, overreaching really. And that would basically cause everybody to be infringing your trademark in that situation. And that's not really allowed by the patent and trademark offices. So the better trademarks, the more distinctive a trademark name is, the better. And Apple is a good example, because you wouldn't expect Apple to be associated with computers and then later phones. So that was a good use of a name in a non-traditional setting. Same with Amazon selling, you know, initially just books and now selling everything under the sun. And I would argue that coming from a global company, Magna, this came up a fair bit. It's important when you're considering a new product name that the name doesn't have bad connotations in another language. You'd be surprised how easy it is to get offside with that. So I would suggest, you know, using Google or another website and putting in your proposed name in a website and checking to see what other meanings it has. So some real world examples are the three here. So there was a Moco car, and that didn't go over too well. And the reason is that Moco means schnout. And so that doesn't really have a nice connotation. So it didn't sell very well in Spanish speaking countries. And the other two names, I'm not going to say what they mean, but if you Google them with that terminology, you'll see it has some rather bad connotations. And so the Fitta was renamed the Honda Jazz, which is still being sold today in Japan. And it's the Honda Fit in North America. And the Pajero was renamed Montero. So the real key with trademark infringement is the likelihood of confusion. That's all you need to remember. So, you know, when you look at that slide to the right, you know, would you be confused if you were served a bottle on the left? Would you think that was a Corona bottle, or would you carefully look at the spelling and see, oh, it's called Sirona instead of Corona? You know, like most people would think, you know, it's a Corona bottle, right? So that's really the key. So if you have a trademark, you know, if somebody has a trademark, Apple or something, you know, you can't have something very similar and be selling the same sort of products. It just wouldn't fly, right? If a consumer would be likely to be confused by your similar sounding name, then you'd be infringing the other party's trademark. So earlier we talked about, I'm not sure if it'll load, BMW. Looks like it is going to load. All right. So BMW actually does sell power tools. So that would be an infringement. Go back to the slide now. Oh, let's see. All right. So in this case, you know, the answer is that you would be infringing a registered trademark of BMW, and they would come off and sue. And other cases like that are family businesses that were named McDonald's, even though that was their family surname. McDonald's Corp has come after many different families that try to establish restaurants with the name McDonald's in it. So, you know, it is what it is. So it's important that you have a registered trademark if you wish to enforce your rights. If you don't have a registered trademark, you can still you know, file things like proof of established reputation, that sort of thing. But you know, the bar is a lot higher. When you go to court, you have to file quite a bit more information to prove that harm was done. Whereas if you just had a registered trademark for roughly $1,000, enforcement is much simpler. So I would encourage any company that's thinking of you know, registering their company name or product name or service name, you know, spend $1,000 and get national rights and make sure that nobody else is having a similar name. Because when you file for a trademark, the trademark office will check that for you and inform you if you have rights to that name or not. And they will actually also advertise before issuing your trademark. They will advertise in their journal, inviting interested parties to oppose it if they wish. And if nobody opposes it and you get a registered trademark, then you basically have your rights. So it's a recommended approach in this case. So to summarize the two forms before I get into patents. So the copyright, the key point with copyright is the original expression of an idea or ideas, and it has both positive and negative rights, and it lasts either 50 or 70 years, depending if you're in Canada or US, Europe, etc. And with copyrights, you do not have to enforce it to maintain your rights. But with trademarks, the key point there is association, like Nike, you think of the association with the company, and branding. And the key issue with trademarks would be likelihood of confusion. So, you have to be careful if you want to avoid infringement. You have to be careful that your name or your logo or etc. is not so similar to an existing registered trademark that companies or consumers, pardon me, would be confused and would think, with the Corona bottle, they would be easily confused in that case. So trademarks have both positive and negative rights as well, and they are renewable rights that go every 10 or 15 years, and you do need to enforce your rights. If you're aware of an infringement and you do nothing about it, then other people have fair game, and then they can use your trademark, and then you would lose all the work you built to build your brand equity. So before we get to patents, which is the more complicated form of IP, are there any questions on either copyrights or trademarks?
I do have one here as well, Tony. So we're talking about infringement on trademarks. We see a lot in luxury brands knockoffs, and they're not going anywhere, and they're still around. So obviously those larger brands, like let's use Nike, they haven't enforced. So can you kind of explain how that they can continue selling knockoffs and what that means?
Yeah, so the knockoffs are obviously infringing the trademarks at the very least. And sometimes they might even be infringing design patents. We'll get to that later. But the problem is that companies have to go to each national government and try to enforce their rights. So they are required to have a registered trademark in each country where this knockoff product is being sold. So they have to proactively hire lawyers, and they have to go to the national governments and say, we have this registered trademark or trademarks in this country, in Canada, for example, and then try to get a court order to seize the product if they become aware of it being shipped into the country. So you do see it all the time, for sure. Sometimes it's just hard it's just so widespread that companies can't keep track. So, but if it's a company that has a physical location in Canada, it would be a lot easier to sue for a knockoff product. But if somebody is in China or Vietnam and making knockoff products of, Gucci bags or whatever they want to knock off, and they just stay offshore and they just ship it in, unfortunately, it becomes harder to track that, and they would have to have some kind of information about, where is it what port is it being shipped into, and who's the receiver, and then they would have to get a court order and stop it there at the port. That'd be the only real way. Otherwise, once it's in the country, then it just gets distributed, and it gets a little bit complicated.
Yeah, so you mentioned, going to the courts, to enforce. So does that become quite costly if you want to enforce then?
For sure.
So do you see a lot of, if there is infringement on a trademark, some companies won't enforce it because of the cost associated?
Yeah, you do, but then you run the risk of, abandoning your trademark, right? That's the issue, right? So I would say, at a minimum, it doesn't cost too much to hire a lawyer and send a sort of a cease and desist letter for whether it's trademark infringement or patent infringement, and say, we're aware that you're selling product with this name that's, substantially similar to our registered trademark, and you quote the number, And then, so we ask that you, please cease and desist or approach us for licensing terms, or that sort of thing. And, they may just blow you off and ignore it, but at least, you've taken the step of trying to enforce your trademark. And that if it turns out that it's too expensive for you to do it, then it's hard for them to say that you've really abandoned it,
So a cease and desist would kind of cover your bases if you didn't want to pursue necessarily go down all the legality fees.
Yeah, I mean, ideally you would follow up and you would file a court action. If you had the financial means to do so, if they ignored your cease and desist letter, then you would, start a court action.
Yeah.
So, that would be the better approach, but I recognize with small companies, they may not have the resources to do that. But if you're a big company like Magna or anybody like that, you would follow consistently all the way through. The lawyer would send a follow-up letter. If it was ignored again, then you would file a court action, and then that would get their attention, right?
Right. Yeah.
And then, of course, if they don't show up for the court hearing, and then the judge will rule in your favor. Then you have a lot more rights. Right?
All right. I'm looking here. I'm not seeing any other questions, so we will continue on patents.
All right. So patents are somewhat, they're a very interesting game, I would say. But there's a lot of confusion about what a patent is and what rights are associated with a patent. So if you ask people what a patent is, you'll probably get 10 different answers. So before I answer the question of what exactly is a patent, I just want to cover the 3 basic criteria for getting a patent. So you can only get a patent for something that is new, useful, and non-obvious. And in Europe, they call that inventive step. It's actually a preferable term. So what that means is if somebody, the product or process, has to be something different that's already known. It has to be useful. That's kind of a given. Otherwise, why would you bother filing for a patent if it wasn't useful? And the inventive step is usually the key. So the argument there is that, somebody skilled in the art wouldn't be able to come up with the exact product or process that you've come up with. It wasn't so obvious or standard engineering that they would come up with it. There was some cleverness behind it. There was something that you did that was not obvious or intuitive, right? So those are the 3 key features everywhere in the world. Doesn't matter what country you file for a patent, those are the 3 basic criteria everywhere in the world: new, useful, non-obvious. But again, that doesn't really answer the question of what is a patent. And a patent is, in a nutshell, all it is a legal contract between the inventor and the owner of the patent, the assignee, and the government. That's what it is. It's a legal contract. And so the deal with a patent is, in exchange for a government monopoly of 20 years, or 14 years in the case of a design patent, you basically, better society by revealing all the, your proprietary information, and you have a monopoly. And then after the patent runs out, society as a whole is supposed to be bettered by what you've revealed in the patent office. And then, that is the whole thing. So it's a legal contract, and it's a national in scope. So if I have a patent in Canada for something, and I don't file for a patent in the United States or anywhere else in the world, people in those other countries can certainly make, use, or sell the same product because I don't have legal protection. They couldn't get a patent on the same thing I did because I've already filed it in Canada and it's been published, but they could copy it if I didn't choose not to file in that country that they're operating in. So every patent is national in scope, and it lasts for 20 years. And there is something called a world patent. There's a treaty called the Patent Cooperation Treaty, and it's not really a world patent. It's a one-stop receiving office for patent filing. So what you can do is you can file for a patent in Canada initially, and then within a year, you can file in the PCT office, Patent Cooperation Treaty Office, called World Intellectual Property Office. And they would then review your application. They would give a judgment or an opinion on the patentability of it. They would look at those 3 criteria, and they would publish a copy of your application with their opinion at the end of it, their patentability opinion. And then what happens is that would be the international phase. And then if you got a good, favorable opinion from that office, then they have something called the national phase. So then within roughly 30 months, depends on the country and details, you would then file in each national office. So you're still having to go in each individual national government office to pursue it, but at least it's a one-stop place that you can file your initial application. And then if it turns out that it's not patentable, then you haven't wasted a ton of money and time filing individually in several countries. So that is part of the strategy that you could use for filing for a patent. So in the slide here, we're using the iPhone example again. So Apple has quite a few design patents on the look of the iPhone, and that sort of cosmetic protection is a 14-year life in the United States and a 10-year life in Canada. And then so that's a design patent. And then on the right is the actual functional or utility patent. And that's the usual patent that people think of that lasts for 20 years and it protects the way things work. So it doesn't have to be exactly, it doesn't have to look the same. If it functions the same way, you would get protection for up to 20 years. So the big misconception I would say that people need to keep in mind for patents is that you don't have the right to actually practice your own invention, which usually people are pretty surprised by that statement. But it's very straightforward. Patents are only negative rights. So if you have a patent, you have the right to exclude others from making, using, or selling a product or process as defined in the claims. And so your rights are defined by the language of the claims, but you don't necessarily have the right to practice your own invention. And I like to use the following example. So if I have the rights to a color TV and another party had the rights to just televisions in general, neither one of us could sell a color TV because my rights that exclude others from color television, I would be infringing the broader patent on all televisions. And similarly, the other party that had rights on television, they could sell black and white televisions, but they couldn't sell color televisions because with my patent, I would be excluding them from using, or selling it. So in a situation like that, normally the parties would cross-license each other because otherwise neither party could sell into the marketplace. So a patent is basically like I like to think of it as a foundation of the house, the specification, the detailed description that you read in patents to kind of describe how a product or process works. And the claims are basically, so sometimes the foundation, the description of the claim, you can actually use it to get several different types of patents. And often the patent office will say, if you file for a patent and you're trying to get multiple claims, they'll, sometimes in a single patent, you might claim the product itself. And then you'll have a set of claims that talks about the way of generating that product. And often the patent office will require you to split your application into two. You call the divisional patent. And in that case, you would have two different sets of claims and patents, all based on the same description. So the same foundation would give you two or more patents. And the other thing about patents that people need to keep in mind is you can't get a generic patent on an idea. So it's always the specific implementation of an idea. So, the patent office, excludes basically business methods, that sort of thing. Computer software can be patented as a method patent, but most business methods in Canada are excluded. So in the United States, it talks about a useful, concrete, and tangible result. So in this case, the ineligible things would be things like algorithms, compilations of data, databases, legal documents, that sort of thing. But the United States is a bit more generous in allowing patents on computer programs and business models or business methods. So a key point that I wanted to talk about is this issue of claim rights and infringing, because this is the most important thing to keep in mind when you're thinking about, do I infringe somebody else's patent or do they infringe my patent? It's all in the claims. It's entire. It doesn't matter what's written in the description. Your rights are solely embodied by the claims that are allowed in the patent. So if I have a patent A it has claims, and I break it down and it has elements A, B, C, D. Oh, this was it's not supposed to have E at the end there. There's a mistake. I didn't catch that. So if product A has just A, B, C, D, and somebody else comes along with a product and they have the same elements and they have an additional element E, the question is, well, do they infringe? And the answer is yes, they do. Because if you have all the elements of a patent, even though you added something extra, element E, you're still infringing. But conversely, if product B had elements A, B, and C, but not D, there's an issue with the figure again. I apologize for that. So patent A is the same A, B, C, D, and product B has A and B and C, but not D. So you've eliminated one of the essential elements. It's not going to be infringing. So we'll fix those graphics. I apologize for that mistake. And the process for filing patents is basically very quickly. You hire a patent attorney or a patent agent to write a detailed description with a set of claims. You file it in the patent office where you want legal protection. You have 1 year to file internationally after you file your first application. And the patent office will check for patentable subject matter. So they will do a search of what's called prior art. So everything that's been published in patents and journals, etc., the patent office will do a comprehensive search to see if anything is already out there that's very similar to yours, whether it's, to see the novelty of it. And then they'll look to see if it's so close that it's obvious that it was almost the same as yours. And then they will issue something called an office action. And an office action, just it's a correspondence from the patent office that normally will reject one or more of your claims, citing, reference A, B, and C that's very similar to yours, and they'll give you the reasons why they think it's similar. And then you have an opportunity to respond to that office action with legal arguments, saying why, humbly, that the patent office is wrong, that they've misinterpreted it, etc. And then normally the patent office will issue a second office action after that. They'll either agree with your arguments and the patent will issue, or they will reject it finally, but maybe allow some of your claims. And then in that circumstance, you either file an appeal or you file a continuation, which is sort of a refiling of the patent application with a different set of claims. And that's a bit of a game where you're hoping that the case, the refiled case, gets assigned to a different patent examiner. So you're sort of using the system and hoping that you'll get a different person that will take a different opinion of what you filed already. So that's sort of the way it works, and it usually takes, quickest would probably be a year. If you pay extra fees, you can get to accelerated examination, but usually to get a patent, it will take you 2 to 4 years. So it's not an easy process, and it takes at least $20,000 per country. So there are different types of patents depending on the country. In the United States, they have something called a provisional patent, and it's sort of an informal patent application, and it expires 1 year after filing. And the question would be, well, why would you file a patent that just expires in a year and doesn't really get you anything? It doesn't lead to anything. And the reason people do that, and what we did in Magna back in the day, but if we came up with a new product and we were going to show it to a customer potentially, we wanted to file a provisional patent because that would establish a filing date with patent office. And then that date that you file the initial provisional patent will effectively have a stop date that anything published after that would not be considered prior art. So that's the only reason to file for a provisional patent, is that if you're intending, if you want to have a shorter window where the patent office can go back in time and look for prior art, and you want to make sure that you're going to file something before showing it to a potential customer or to the public, you want to make sure that you file a provisional patent. There's also something called a design patent, where you would just, protect the ornamental design of something, like that iPhone example earlier, or shoes or jewelry or something. And then the third main type of patent would be a utility patent, which protects the functionality of something, and it has the most broad coverage, and it lasts the longest, 20 years versus 10 or 15 for a design patent. And in Canada, there is no such thing as a provisional patent. So that's an important thing to keep in mind. So in Canada, if you wanted to protect something and you were going to show it to a customer or something, you'd either file in the United States as a provisional patent, or you could file it in Canada as a national regular patent. And then within a year, you could then decide to file it in another country. So Canada instead has something called an integrated circuit topography that protects electronic circuits. We have something called industrial design, which is the same as a design patent in the United States, but it only lasts 10 years instead of 14. And we have the same utility patent, same as the US, 20 years from filing. So those are the main differences between Canada and the United States. So for design patents, it's important that they're not functional. So if you look at the design patent, like the iPhone example, it only consists of drawings. It has no verbiage other than, I claim this electronic device as shown in the figures. So your drawings are your entire scope of the claim. There's no detailed description of how things work or look. It's basically you show different views of an object, three-dimensional, etc. And that's it. And the advantage of that is that it's much faster to get a design patent, usually 6 months, and it's a lot cheaper. So essentially, you're just hiring a draftsman and a patent agent to prepare a set of drawings to show in different views what you're hoping to sell. And you file it, you get an answer within 6 months, and then if somebody tried to make a knockoff product, as Brittany mentioned earlier, you could go to the government where you have a national patent, design patent, and you could just say, look, I have this design patent that protects my Gucci bag, and here's a Gucci bag that looks exactly the same, but it's not licensed by me, it's an infringer. And that would be enough to stop that importation potentially of that infringing product. So it's sort of a quick and dirty, I wouldn't say quick and dirty maybe, but it's a low cost way of getting some protection. It would not protect people from reverse engineering your product or process, but it would protect your company from people that are just making blatant knockoffs. So in general, if you think about, why you want to get a patent, you want to protect your existing product, you're hopefully you're going to get profitable technologies. You can generate revenue through licensing. There are many instances when you should not bother to get a patent. So if the invention will be difficult to enforce, or you're going to have a very short product life, I wouldn't bother to get a patent, because it would take 2 to 4 years to get one, and then you've already moved on to the next iteration of your product, so it wouldn't really be beneficial to you. The other thing I would keep in mind with this is, because there's a public disclosure when you well, that's a separate, actually that's a separate topic, but when you file for a patent, it gets published within 18 months of filing. And basically, you've now educated the world about your product or process and how it works. And so you may have to ask yourself the question, do you really want to do that? Do you have the financial resources to enforce your patent, to spend the $20,000 and up and wait 4 years potentially to get a patent, and then prosecute it if people are infringing it. Like it's a judgment call. If it's core to your technology and it's important to you and you want to make sure that nobody else is playing in your sandbox, for sure you should do it. And then potentially you can license other people. If it's a game-changing kind of technology, you definitely should file for a utility patent and try to get a monopoly on that. And hopefully people will come knocking on your door asking for a license. But it is an expensive game, so you do have to keep that in mind. And the last bullet point there about a public disclosure. In Canada and US, if you publicly show something that's patentable, you have up to a year to file for a patent. But in Europe and every other country in the world, if you've made a public disclosure of a product or process, you are barred from filing for a patent. So that is something important to keep in mind as well. So if you're going to go to a trade show or something, you're going to reveal a new product or process, you better make sure, if you want international protection, that you have filed at least a provisional patent in the United States, if not a national utility filing in the United States or Canada. So the question always becomes, how do you enforce it? So you can hire monitoring or watch services if you don't have the financial means to, or the technology expertise to look at the patents that are published every week in the patent offices. So you can hire services that will do that for you. And then if you find something that seems to be infringing your patent, you would have to hire a lawyer and send a cease or desist letter through your lawyer and then follow that up. And if you don't follow it up, then you lose your rights to it. You can use mediation or arbitration. And in your cease and demand letter, you could either be very aggressive and tell them to stop immediately, or we'll sue you to kingdom come, or you could offer an olive branch and offer some licensing terms as well. And the reason I talk about that is you need to think about a patent infringement suit taking years and at least $2 million. And so it's a roll of the dice too. So there is a risk when you get into a patent infringement lawsuit that you spend, $1 million, $2 million, hired a lot of lawyers, you have discovery phases, etc. People are making all these fancy legal arguments. If it turns out the infringement party finds prior art that you and the patent office originally hadn't considered, and it would make your patent invalid because it basically showed the same thing more or less, the patent office could then hold your issued patent invalid, and then you would lose all your rights. So that is a risk, and I've seen it happen many times where parties will enter into an infringement lawsuit, and during the legal arguments, the other party that's being sued finds prior art that renders the initial patent invalid, and then the lawsuit just goes away, and then the company that launched the lawsuit now has lost all rights. So sometimes it would make more sense to play nice and offer licensing terms, and then both parties could potentially win. So in terms of like competitor analysis, I like to think of patents as a very good form of competitive intelligence. So if you use Google Patents or many other websites, you can search by keyword or by technologies. You can look at patents that are similar to your own, or products that are similar to your own, and it'll often help identify to you competitors you may not be aware of, or it may give you insights in terms of what your competitors are filing, and perhaps they're filing things that would impact your current line of business. So that sort of thing is important. If you have the time to do that, it would make some sense to look at least on a monthly basis, if not weekly basis. Take a look at what's being filed in the patent office, make sure to see where your competitors are doing, and also this issue that I've written here about freedom to operate. And so what freedom to operate means is you may be happily churning along, making a product or process, not aware of any issued patent, and then suddenly you may get a letter from a competitor, basically saying that they've now been issued a broad patent, and it would cover what you're doing. So you will no longer have the freedom to operate because you have negative rights with patents, right? So if somebody in the future gets a broad patent that covers what you're doing in a business sense, potentially they can stop you from operating. They could force you to take a license from them, or if they didn't want to play nice, they could just say cease and desist, you're out of business. And then you're into a very long, drawn out, expensive legal battle. And so one strategy you can do for that, that we did in industry as well, is you could file for patents on what you're doing. And so, for instance, you have a new gadget that you've invented, and you don't really have the financial resources to spend $20,000 per country to protect it. You could just file that patent application in Canada and then let it expire. Don't pay the maintenance fees. The patent application publishes, and now in the future, what that does is prevents other people from getting a very broad patent that would cover what you're doing, because now that becomes prior art. Your patent application that you've abandoned publishes, and it's now available anywhere in the world. And so when a patent office reviews a new application from a competitor that's trying to stop you from operating, trying to get a broad patent, that patent application that you filed, it now becomes prior art. And so it's a protective way of ensuring that you have freedom to operate in the future. So sort of a summary here. So the copyright is the expression of the ideas. It's positive and negative rights. It's 50 to 70 years term, and you don't have to enforce it. For trademarks, the issue there is really association or branding, positive and negative as well. The key issue there would be likelihood of confusion for infringement, and you do need to enforce your rights or lose them. And in patents, the key thing to remember is that it's a legal contract, and it has only negative rights, the rights to exclude others from making, using, or selling in each country that you have a patent. And it lasts for up to 20 years if it's a utility patent, and if it's a design patent or industrial design, it would last 10 or 14 years, pardon me, depending on the country that you filed in. And you do need to enforce those rights as well. So here on Crowe we do both shreds, SR and ED, scientific research and experimental development, as well as patentable consulting work. And in both cases, patents and shred, they must cover new technical ground. And since a patent has to be new, useful, and obvious, and non-obvious, pardon me, it's very similar to the shred criteria where the project must be advancing the base technology and can't be routine engineering. So what we find, if a company is doing patentable work, whether or not they've decided to spend the $20,000 to file a patent, normally if they have patentable technology, they're also qualifying for shred rebates. And so we have a dedicated team that can do either or both IP and shred. So our team here is led by David Tung, our practice leader in Kelowna, and myself as a senior manager in Vancouver, where I usually do things related to engineering, manufacturing, and specialty things like food and beverage or cannabis, licensed producers, that sort of thing. And we have somebody in Edmonton, Chen Sai Lai, and his expertise is life sciences. So usually medical doctors who are doing a lot of research or dental claims, that sort of thing. So that's our capability in terms of shred and in intellectual property. So hopefully I can answer any more questions if anybody has any.
Yes, they do. Here we go. We do have a few here. So we'll go on the patent train, and then we've actually had some come in around copyright. So first on the patents here, Tony, if someone has a patent in the US only,
Right.
can it be copied in Canada?
Yeah. Yeah, the answer is yes. So you have the negative right to exclude others from making, using, or selling. So if you have a patent in the United States, you can't make, use, or sell that product in the United States. But if you're here in Canada and you're not selling into the United States, and you could potentially just completely copy somebody's product and only sell it in Canada, and there's nothing they could do to you. Absolutely nothing. And it's not like they can come after the fact, like 2 years later, and say, well, I think I'm going to file for a Canadian patent now to stop you from doing it. You basically have 1 year from your initial patent filing to choose the countries you want protection in. And if you haven't filed in Canada, in this case, there's nothing that company could do to you in Canada. If they didn't already file for a patent in Canada, there's nothing they could do if you were copying them.
Okay. You can stop your screen share as well here for this last question. And then we've got, how can one determine practically and confidentially if copyright has lapsed? So example, reusing, reappropriating images, diagrams from, let's say, an old manual from the 1920s.
Yeah, you'd have to look at, if what's the origin of that copyright, and then see if that person has died, and then you have to add the 50 or 70 years. Unfortunately, it's not a simple
Okay.
concept. If somebody filed the source code of a computer program as a copyright, which you can do, you can check registrations of copyrights in the patent and trademark offices. But to answer your question directly, if somebody wanted to do a clip of something that was, from the 1920s, it's probably okay. I mean, who would be enforcing it, right? I mean, that would be the question too, is if it was that long ago, the owner of the copyright, if it was a company, would they even know you're doing it, and would they bother to enforce it?
Right. Okay. Yeah. I'm not seeing any other questions. I think we're good on that front. I'm looking at my chat here. So for everyone, we will be sending a recording out. You'll have that by tomorrow of this webinar. You can share it. You can also access it on our website, and we will share the slides as well, because I know there was a lot of information shared today by Tony that you might want to just actually look at the slides to reference rather than the actual webinar. So we will share those as well, and they'll be copyrighted. Awesome. Well, thank you so much, Tony. And thank you to all of our guests. Again, if you have any questions, please reach out to your local Crowe Mackay office. And we hope you're doing well. Stay safe, and we hope to see you soon. Bye-bye.